and Culture here at Ohio University. On behalf of the CLJC, it's my pleasure to welcome you to our Wrongful Conviction Day event, Forces of Freedom or Fraud, Do Conviction Integrity Units Matter? This event this evening is co-sponsored by the Ohio Innocence Project and the OIP-u chapters here at Ohio University and at the University of Cincinnati. Wrongful Conviction Day is a day to raise awareness to the causes and remedies of wrongful convictions, as well as the tremendous personal, social, and emotional costs that wrongful convictions can bring to innocent people and their families. Each of our panelists this evening works in or has personal experience with wrongful convictions. To tell you a little bit more about OIP and OIP-u, I've invited Kira Wright, who is a senior political science major here at Ohio University and who is president of the OIP-u chapter. Kira?
Hi, everyone. Thank you so much for coming to this event tonight. The Ohio Innocence Project was founded in partnership with the University of Cincinnati College of Law in 2000. Since its founding, Ohio Innocence Project has freed over 30 Ohioans who served approximately 600 years for crimes they did not commit. OIP continues to devote itself to freeing people who are in prison for crimes they did not commit. A team of 5 lawyers and law students investigate hundreds of claims each year. In addition, OIP advocates for legislation that reforms the criminal justice system to prevent wrongful conviction. OIP has been involved in major reform efforts, including the SB 77, which in 2010 mandated police departments to use best practices in witness interrogations, photo arrays, live lineups, and in collecting and preserving DNA evidence. More recently, OIP was instrumental in bipartisan efforts to reform the compensation system for people who've been wrongfully convicted. OIP's most recent effort on Capitol Square is a bill that would require Ohio's law enforcement to record custodial interrogations. OIP's public education programs include work with professional organizations, community groups, and in high schools and colleges around the state. The largest education program is the OIP-u network, including the chapter at Ohio University, as well as 10 other universities around the state. On behalf of OIP-u, or OIP's Board of Advocates, staff, and clients, thank you for joining us today and taking the time to learn more about wrongful conviction.
Thank you, Kira. We'll now turn to our attorney panelists, but before we do, I just want to lay out a ground rule. We're streaming online live through both YouTube and Facebook. We do have time for questions at the end of the program, but panelists are happy to take your questions throughout the program, so please go ahead and put those into the chat on either YouTube and Facebook, and we'll work our way getting through them. So first, we're going to hear from Pierce Reed, who's an Ohio University alumnus, an attorney and program director at the Ohio Innocence Project. Pierce is going to be explaining to us conviction integrity units, followed by Tom Costello, who's also an Ohio University alumnus and a former CLJC faculty affiliate, who currently serves as an assistant prosecuting attorney in the Wayne County, Michigan's Conviction Integrity Unit, who will be giving us his perspective as someone who works on the inside of the Conviction Integrity Unit. And finally, we'll be hearing from Mallory Thomas before we get to the exonerees, who has served as a staff attorney for OIP and who helped exonerate Charles Jackson, one of the exonerees that you'll be hearing from this evening. So with that, I will turn it over to you, Pierce.
Thanks, Larry, and a special greeting to everybody in Bobcat Nation, the greatest nation in Ohio. Thanks for taking time out tonight to learn a little bit more about conviction integrity units in particular, but also just generally for your willingness to learn about wrongful convictions. We just finished celebrating and observing International Wrongful Conviction Day. And we do that as a reminder that for every man or woman who has been freed, there are still many, many behind bars for crimes they did not commit. So in that regard, it is a solemn observation and one that we know extends beyond them, but also to their families and their communities. So please be mindful of that. And I think tonight you'll understand at the end of this program how important it is that we all work to both prevent wrongful convictions, but also that we work to remedy what has happened to men like Royle and Charles, who are two of the finest human beings I have the pleasure of knowing. But specifically tonight, we want to talk about one aspect of wrongful convictions that gets a lot of attention. It is what is known as a conviction integrity unit or a conviction review unit. And these are specialized units that are typically found in a prosecutor's office. In Ohio, it would be a prosecuting attorney. In other states, it would be called a district attorney or some name like that. But the idea behind a conviction integrity unit is that you have a group of attorneys who are part of the prosecution team independently looking at claims of innocence and wrongful conviction from within. And part of the idea is that they are the experts at figuring out if it's a viable claim of innocence. In the greater debate about criminal justice reform, a lot of attention gets put on conviction integrity units, and sometimes it seems that they are more dominant than they are. Only about 2% of prosecutors in the United States have some form of conviction integrity unit. Most of those have occurred within the last 10 years. In Ohio, the first prosecuting attorney to create a conviction integrity unit in a formal way was in Cuyahoga County, which is home to Cleveland. By 2015, there were about 24 conviction integrity units sprinkled around the country, and they were responsible for about 58 exonerations. In 2020, there's a much wider range of estimates about how many conviction integrity units exist. Some people put it at about 35 or 40. The New York Times recently reported it was around 60. That would include 2 or 3 statewide organizations that don't operate within a county or district, but have jurisdiction over a state.
Hello?
Okay, I think we may have lost Pierce. So while we're waiting for Pierce to come back into the room, maybe we could move on to Tom, who actually works in a conviction integrity unit.
Okay, thank you, Larry. Hello, Bobcat Nation. It's good to be back, even though it's virtually. I appreciate the opportunity. I'm honored to be here, especially with Royle and Charles, who they've done the real work. And folks like us are just honored to be a part of freeing them. I thought I'd just give you a little bit of background about, oh, there's Pierce back. You want to pick up with him?
I don't see Pierce.
I see him here, I just can't hear him.
Okay. Pierce, are you here?
Literally or figuratively?
There you are. We lost you.
I'm back. But I think it's fine to go on to Tom. I mean, these are the people who are the experts in conviction integrity units. So,
okay, I'll keep going then. Thank you. So I thought I'd just give you a little bit of background about our unit, how we came into existence, and some of the challenges we face. You know, as Pierce had mentioned, you know, unlike being an Innocence Project organization like at UC or, you know, Barry Scheck's organization, we're actually embedded in the prosecutor's office. I find it odd at times to call myself an assistant prosecuting attorney when I'm actually doing the opposite. But we started in January of 2018. At that time, there were, as Pierce mentioned, I think about 30. Now that number is in the 60s. In almost 3 years, we've accumulated over 1,450 applications, claims of relief, where prisoners have written us to look at their claim of innocence and see if they're likely to get some relief. To date, we've granted relief in 23 cases. We have probably about a handful pending, and then maybe if we're lucky, we'll get those done before the end of this year. As I said, we're in the Wayne County Prosecutor's Office. We're about a staff of 8. We have an administrative person. We have 3 full-time attorneys, including our director. I think one thing that's key, that's not always the case in a lot of CIUs, is we have 2 dedicated full-time detectives as investigators. They're part of our unit. They're not part of any other detective bureau or homicide squad or sexual assault unit. They're ours, and they work on our cases. Each of them have over 20 years in homicide, and one even has a little bit of experience in cold cases. So this really is a good fit for us. For students, we do have interns. We have paid interns, and we have externships if you're looking for credit from your school. So, and then we have 2 other part-time lawyers that work 20 hours a week on the cases. That's kind of, how we started. Kim Worthy, our prosecutor, I think, and I think Pierce touched on this a bit. Leadership is very, very important, and the prosecutor for Wayne County has supported this unit, was willing to go to the commission recently to double our budget, double our size, but with the pandemic, that's sort of kind of been put on hold, but we hope we can increase our staff so we can do more work. I think one of the keys, difference, a lot of prisoners, once convicted, will take the path of the appellate path through the legal system. We don't do that. We don't handle questions of law. We handle only questions of fact. So we look at a case from ground up. Sometimes I think we probably have done a better job than what was done initially. That's no disrespect or harsh criticism, but now we're chasing down everything. Sometimes it leads to a dead end. Sometimes it bears fruit. Sometimes it leads us to 6 more paths. But that's what we do. We do a very, very thorough investigation. Prisoners can apply. The evidence has to be new. If it was litigated, we won't review it. It has to be new. And a lot of times that comes in the form of another witness, through an affidavit, maybe science or DNA. The important thing too is, even if science was available at the time, if it was in the 90s, in that some of those tests have been refined now, so we'll go back and we'll retest it. We have a good relationship with Western Michigan Cooley, their Innocence Project, and they do all our DNA work for us through either MSP, the Michigan State Police, or some independent labs. The process goes where we investigate it. We have a team meeting, and there's always a lead attorney and a lead investigator on the case. They present it to the team. We're all consensus based in the decision. So the case doesn't move forward unless everyone on the team is 100% behind it. Once we reach that, it goes to Prosecutor Worthy's chief of staff. She does a preliminary review, which allows us to, fine tune it before it gets to the prosecutor, and then ultimately goes to Kim Worthy, and she is the ultimate decision maker on the case. Sometimes she may push back and say, well, I need a little more info on this. What about that? And we go back and do it. I think the thing I've learned, and I think everyone else that's on this call understands, this is a marathon and it's not a sprint. We were in a meeting this week and had, mother thought, the way we were going, it was right around the corner. And, we had to say, no, we're not quite there yet. It's quite a while to go, which is disheartening for them, but we're making progress. I think just some of the things we find, just comment just on the process, and is that You know, the passage of time sometimes is our enemy. A lot of these cases that are 25 and 30 years old, I can't find a police file. I can't find a trial transcript. I don't think I've had a case where someone that was a witness is now dead. So that makes it extremely difficult, you know, to verify things, track things down. People have moved. It's that's always a challenge. You know, the other thing too is I mentioned earlier, we are a unit within the prosecutor's office, and we're working to maybe correct a mistake that was made. I think folks in our office are beginning to learn our value, but you know, sometimes there's a little bit of pushback or you know, what are you doing or why are you doing this? But by and large, we've been well received. We've been well received by other prosecutors in the office and the police. I think the police, a number of times, officers where we've started you know, on a case have said, you know, I'll help you. You know, it would be horrible if someone was sitting in prison for something that they didn't do. So I guess I'll kind of put a pin in it there and take any questions later whenever that comes. Thanks.
Mallory?
I was gonna let Pierce pick up where he was so he can keep doing his spiel before I just rail into Cuyahoga County, so.
That's a big build up. Well, I think going back to where I was is just to say that in Ohio, there are 88 counties, each with their own prosecutors. And of those 88 counties, we know of 3 that have a conviction integrity unit in one form or another. Cuyahoga was the first where Cleveland is. Franklin County, which is where Columbus is, has not an officially promoted conviction integrity unit, but for all practical purposes, has a de facto one within the organization that works exceptionally well. It has really drawn a lot of support from our clients who have been exonerated through that process. But one of the tendencies in the current conversation about conviction integrity units is that there's almost a belief that these are going to be the silver bullets that make everything all okay with wrongful conviction. And I think that's really dangerous thinking. That's dangerous in any situation because we can't look for magic bullets. We have to look for systemic reform that prevents wrongful convictions from occurring to begin with. Because even the most successful CIU is going to be reacting to a tragedy that's already occurred. And as Tom points out, very importantly, it takes years to get through those cases. And in those years, the men and women who are wrongfully convicted suffer, but there's no justice for the victims either. And that's one of the things that I think is most compelling if you're a prosecutor, is to recognize that you serve because you are trying to protect the community. And in a wrongful conviction case, you have not protected your community. In fact, you may have harmed it more because there's a belief that justice has been done when in fact it hasn't. None of this should dissuade us from CIUs necessarily. I am not friends with Tom. I hadn't met him before this event, but the reputation of his office is known nationally because it is a conviction integrity unit that is led by people who are very genuine in what the mission of that unit is. And there are several other ones around the country. In Dallas, in 12 years, that CIU has released 36 people through exonerations. In Philadelphia, in just 2 years, a progressive mind prosecutor has led 10 people to exoneration. And in Brooklyn, a unit that's been around for about 6 years has led to the release of 27 people. And if I have my stats right, I think Tom's unit has done even more in about 3 years or so. Mm-hmm. And so we should recognize that these are indeed powerful tools, but they're still a part of government. And government only works as well as the leaders at the front of that. This is an election year everywhere in the country. It's an election year in states like Ohio and Michigan, battleground states. So all of you are well aware of political rhetoric and campaign advertising. And the mere fact that someone labels themselves as progressive or reformer doesn't mean that it's true. So it's important not just to vote, but to vote in a very educated way. You have to be as smart as a consumer when you're shopping for political candidates as you would if you were shopping for a car. The political candidate is ultimately going to have much more influence on your life than your car. And we need to approach it that way, especially in a state like Ohio, where we elect prosecutors, we elect judges at every level of the judiciary, including 2 Ohio Supreme Court justices this year. So for those of you who say you care about wrongful conviction, you have to take the time to make sure you're informed, because not voting or not voting with some forethought is incongruous with any belief at stopping wrongful conviction. And you need to look at information about conviction integrity units in that way. Yes, they can be incredibly powerful, but people have different experiences with different CIUs. And that's part of why we wanted to make sure that we gave an opportunity to Mallory and Charles and Royle, because they are the ones who are the experts as people who have worked very closely with CIUs here in Ohio.
Mallory?
Okay. So my name's Mallory Thomas. I was a staff attorney with OIP, and I recently just moved to Cleveland to join a criminal defense firm to fight the good fight, right up and personal. And while I didn't go to OU, my dad did, so I feel like that should give me a little bit of credit, but whatever. I did go to Ohio State, so if you want to hold that against me, that's fine. But Royle is really like the who has dealt with the CIU more than Charles or I have, and he can speak more to that experience. But having seen what Royle went through and everything, I naively thought, maybe there is some good that could be done at the through the CIU in Cleveland, and then I had Charles's case, and then I learned that that's not really true at all. Charles's case is a very obvious Brady violation, NAPU violation case. It's very obvious who committed this crime, and it wasn't Charles. And they fought us tooth and nail. And we didn't go through the CIU or anything, but just their prosecutor's office fought tooth and nail and keeping him locked up. And they, once they did agree to give him a new trial, and even when they later dismissed the charges against him, they specifically went out of their way to make sure to say, this is not an exoneration. This is not it. That's not what's happening here, which calls into question the credibility and, the true heart of how do you have a conviction integrity unit when we've showed you that this conviction lacks integrity, but you're like, no, it is absolutely not an exoneration. It is. They dismissed the charges and he's exonerated and he's been out, for almost 2 years now. So it's weird to be so personally and morally offended by something that you're allegedly campaigning here in Ohio. It doesn't make any sense. Those two things don't match up. They just don't. And I wasn't Royle's attorney, but I sat by and watched the months and months of long battle that occurred between Royle's counsel and OIP and the conviction integrity unit. It was a lot of gaslighting, if you will, and a lot of broken promises and unfulfilled promises, and a lot of just saying things to appease people for the moment, or are trying to buy themselves time, making, adding things to the list before they let Royle out that had absolutely nothing to do with anything, and they were just trying to buy themselves more time. And at the end of the day, Royle's sitting in prison. So I don't know what I's they were trying to dot or what T's they were trying to cross, but like OIP-u and Kim Corral, who's a Cleveland attorney, went to the conviction integrity unit with Royle's case packaged up and with a bow and was like, here you go, here's what happened. And it took several more months before, they agreed to release him. And it was this whole song and dance. It was, and Royle really was like the only real success case out of the CIU. And they started, 3 years ago. So you have, like Philly and the other numbers that Pierce was throwing out, Cuyahoga is abysmal in comparison. And I think it really just goes to the heart of it was a successful political platform to run on. And they really had no interest in actually following through with that. And I think that's blatantly evident. It's not like there is a lack of wrongful convictions in Cuyahoga County. That's not the issue. The last 5 or 6 in Cleveland, or in the last 5 or 6 OIP exonerees have been out of Cleveland. So it's not like there's a shortage of those there. There's a shortage of CIU cases that are being seriously considered, that are being seriously investigated. And I think a large part of that, weirdly enough, even though Michael O'Malley ran on this platform, he seems to be, from what we've heard from other people and just our experiences, he seems to be the most offended by this whole concept. So since he's the elected prosecutor, everyone else basically has to fall in line with that. And I think that is reflected a lot in not just Royle's case, but in Charles's case as well. The prosecutors we were working with personally would tell us, you could tell they felt one way. They would report back to the head honcho and come back and things would be completely different. So it just really calls into question the integrity of their conviction integrity unit, because it really just seems like a farce and a front to get voters, really. And he ran, he was elected as a Democrat. So you would think, that sounds progressive or whatever, if you will. But like Pierce was saying earlier, you really have to do your research and you really have to look into people and who, their track record and what they're actually doing in office, because I would venture, my opinion is he's not progressive at all and has made this into kind of a whole ego thing about himself, even though all of these convictions happened long before he ever took office. So, seeing Tom and other places like that remove the ego from it, I think is shockingly such a hard thing for a lot of people to do. And it's just so silly and so simple. So not to, just rant for 5 minutes straight, but that's, my thoughts on our conviction integrity units here. There are, like Pierce said, even though Franklin County and Columbus doesn't have like an official unit, I think they have a more, they're definitely more open and actually function more like a conviction integrity unit than Cleveland's does. And there's some talk about hopefully one happening in Cincinnati as well. So I think for a long time, Cleveland's been able to get away with it because they're kind of really the only one here. And so once, hopefully other ones start to pop up and start to actually function as one should. Also currently right now in Ohio, we have a conviction integrity task force, or wrongful conviction task force, technically is what it's called, where, Pierce and Mark and a bunch of other people in OIP and other people around the state are working on, creating collaboratively with the prosecutor's office, better practices and stuff around the state. And not to get too much into it, but, the most recent announcement was that basically the prosecutors in Ohio were no longer going to participate in this task force because they didn't really find it necessary, which again, I think speaks volumes, especially out of Cleveland, having a CIU to just refuse to participate in a task force about wrongful convictions, again, just says so much about what actually the practicality of like what that unit is doing. So that's my rant.
Stephanie, Mallory, there is a question from Stephanie. I think you partially answered it with what you had just said, but you mentioned that Cuyahoga and Franklin County have CIUs. What is the third county out of the 88 in Ohio, and how can more counties join in adding these teams to their prosecutors' offices?
So Hamilton County, which is in Cincinnati, is the third county has discussed. There are, with the election coming up, there are elected prosecutors who may or may not be voted out of office, and if they are, then their incumbents may have discussed starting one there. I think the biggest thing comes down to funding. A lot of places just don't have the money. Tom was talking about hiring on more attorneys and, having detectives who are dedicated to that. I think it honestly just comes down to money, especially in the smaller, more rural counties. But I think for the large part, a lot of our exonerated cases are from those main three: Cincinnati, Columbus, and Cleveland. So if we could at least get 3 functioning actual CIUs up and running in those 3, I think it would open up, funds, or, even how we have a, Ohio Public Defender's Office, a statewide public defender's office. One day there could be a statewide CIU, but it's baby steps. So I think, honestly, I think it just comes down to funding and it being such a new concept in general. It is definitely more progressive. Not everybody's there yet, which we can all appreciate, but I, like Tom said earlier, it's definitely taking steps in the right direction. But it sucks when there are ones here who are allegedly up and running and don't do anything at all. So,
Larry, could I just interject one thing?
Please.
The Summit County prosecuting attorney, which includes the Akron area, has a new conviction integrity unit as of the end of 2019, I believe. And in reference to Mallory's point about the prosecutors not taking part in the task force any longer, as I understand it, there were several arguments as to why that was occurring, or reasons for why it was occurring. One of them is that the Ohio Prosecuting Attorneys Association did release a public statement that noted it was encouraging its members to create conviction integrity units. I don't know what their success has been with that. And as Mallory points out, every good unit is going to require a certain amount of funding. But that is one of their stated rationales for not participating in the task force, because they believe prosecutors can solve this problem through conviction integrity units.
And Pierce, there's another question that you may be able to answer. The question is, who funds these programs? Who funds CIUs? So maybe Pierce, you could talk about that, and maybe Tom, you could as well.
My understanding of it is that there's a certain amount of money that each county prosecutor in Ohio is budgeted, and each prosecutor has a great deal of discretion in how he or she allocates those funds. One of the things that complicates it in a state like Ohio is we have a diversity of people, not just in protected class status, but in all kinds of different terrain. So we have 7 or 8 major urban areas. We have exceptionally rural areas, parts of the state where even internet access can't be taken for granted. And then we have all kinds of places in between those two kind of extremes. And prosecutors have to deal with issues on a local level. And as we've all found in Ohio over the years, there have been a lot of challenges that prosecutors have faced, particularly around opioids and other aspects that have really just been devastating to communities, including criminal justice systems. So for some prosecutors, I'm sure there just aren't enough resources to devote to a conviction integrity unit if the biggest need in their particular jurisdiction is to support a specialized unit that may divert people from prison into drug treatment facilities. We do not fund in the way that I think is probably the most equitable. It's always kind of reminded me of how we handle school finance in Ohio, which, despite being declared unconstitutional, is still the way that it operates. So there's a lot of reasons for why it doesn't happen, and funding is not as secure for conviction integrity units as it may be for other programs that prosecutors operate.
In Wayne County, we're funded right out of the county revenue streams. So the Board of Commissioners, the county commissioners, much like a legislature, grants us our operating budget every year. What we've done to supplement that is we've applied for and received 2 federal grants around forensic science and DNA testing. So that allows us to work with Cooley in that sense, and it's helped us fund a law clerk, one of our detectives, just those 2. So we've kind of had to go out and pull some money from other sources.
Great. Mallory, do you want to introduce Charles and Royle?
Yeah. So with us are 2 exonerees. Royle specifically worked with the CIU, so not to overshadow you, Charles, but I feel like I'm going to a little bit. So I'll start with Charles really quickly. He was convicted for aggravated murder and attempted aggravated murder, spent 27 years in prison for obviously a crime he didn't commit. Back in 2016, we did some public records requests, got police files and prosecutors' files back, where we found Brady evidence, and we moved forward with a hearing, found more evidence that witnesses lied at trial. And the case against him back even in 1991 was flimsy at best. So the state ended up agreeing to a new trial. They held that over his head for like a year before finally dismissing the charges. But just the way they were so reluctant to, admit wrongdoing in Charles's case, I think is very demonstrative of, the CIU in general. And then Royle specifically had experience with the CIU. He spent 15 years in prison for a crime he did not commit. There was a murder, and they had one of the 2 guys that they believed was involved. He claimed he wasn't the shooter. It later came out during sentencing that this second guy said, "Oh yeah, actually I was the shooter, and this other guy was with me. Royle never was." Took 15 years eventually to get to the, Royle filed multiple post-conviction motions, all denied. And eventually they get up to the CIU, and, he applied multiple times to the CIU in Cleveland. They denied it, eventually decided to take it seriously, and it still took like over a year from when they, applied or said they would investigate to when he got out. And that was, a lot of promises were made, a lot of rumors were floating around about, he's going to get out now, and then that never ended up happening. So it was, Royle is out now, but so it works, but, not as well as anybody would like. So I would definitely don't want to tell their stories, so I want to pass it over to Royle.
So, I can't see everybody. My name is Royle Saylor. As Mallory told you all, I served 15 years. I was sentenced to 28 years to life for aggravated murder that I didn't see, that a friend of mine had committed and sentencing. he admitted to this crime, and I was still sentenced as the shooter. So when the conviction integrity unit came about in 2014, I think, I had told my lawyer, Kim Corral, about it. She wrote up an application. We sent it in. McGinty was the prosecutor then. They sat on it for like 8 months with no response, no nothing. Then they denied it. And so we went back in, filed it again with them all over again with new evidence. I went had like Bill Evans, #1 top polygrapher. Polygrapher. Sorry about that. Polygrapher, and they had already told us that the CIU had used him or took his word. So I passed a polygraph test. My co-defendant took a polygraph test saying that he actually committed the crime, and they still denied my application after months of just sitting on it. They denied it. So when they took office, the new prosecutor with Michael O'Malley, it was the same run around for a minute. He made promises. Basically, he was going to look into my case. And so if I didn't apply the pressure I did with my family and the media and the OIP, I would still be in prison because the pressure, people applying pressure to that office and that unit is what brought me home. My wife going down there, sitting down there for hours, then my lawyer, then my mom, because there was no communication whatsoever. Like they would just go missing for months at a time and not tell us what they was doing or anything like that. And then fast forward, because it was 2 individuals involved in this case. And the second individual came forward 14 years later. He admitted that he was there with the actual shooter. I was nowhere on scene, anything like that. I had no involvement whatsoever. Every witness in this case said it was 2 guys that looked alike, came together, and they left together. One of them was the shooter. I still sat in prison for like 7 to 8 months after that, after he came forward. And the head of the CIU came and saw me in prison in Lucasville. He drove 4.5 hours and he came and saw me in prison. And he looked me in my eye and told me that they were still investigating the case after everybody had confessed, after the star witness had came back and recanted. He told me he was still investigating the case. He had time. He needed some more time to look over it, and left me in Lucasville prison for like 6-7 more months. And the actual guy that was there still didn't go to prison. Like, this conviction integrity unit, it was, even though they came to me and told me that it was basically they used my freedom as leverage. Because they came to me and told me that, well, we know you didn't commit the murder, but you told a lie during trial. So you could take this perjury charge and this obstruction of justice charge, 5 years max on each one, ran consecutive, which would bring it to 10 years time served. You can go home today. And that was like my only choice. Either I go home today, take this deal, or you go back to the cell and you file a new trial motion, and we might deny your application. So, I'm happy to be free, but the actual procedure they went through for me to get my freedom back was just not right. It needs to be handled differently. It needs to be more communication on both ends with the CIUs. And I think that they should be freeing more people, because I know a lot of guys' cases that I read when I was in there should be out right now. And I know they filed applications because I showed them how to do it, or I had my lawyer that showed her how to do it for them. And they just not freeing these guys, and it's not right.
Thank you, Royle. There is a question that's been asked, and that is, can you explain what Brady evidence is? So I don't know if Mallory,
I'm swinging it. So, sorry. So Brady evidence is it's a Supreme Court case, Brady versus Maryland, and essentially, if the prosecution withholds exculpatory or evidence that would help the defense or the defendant, they have to turn all of that over. So if that's a witness who said X and now is saying Y, you need to know about X, because that goes to their credibility as a witness. If there were DNA results that pointed to somebody else, that is something that they need to turn over. If there's a suspect description that doesn't match the defendant, that needs to be turned over. So it's basically everything that helps the defendant needs to be turned over. And if it's not, that is a Brady violation, which is a constitutional right to fair trial violation. And that's what will grant you a new trial. Yeah, essentially.
Thank you.
Yeah. So Charles, do you want to talk about your experience?
My name is Charles Jackson. I did 27 years, 6 months, and 20 days for a crime I didn't commit. Mallory explained it, and I ain't gonna waste no time going back over it like that. But I got out through the Brady violation, and my Brady violation was that I didn't have X and Y, like she was saying. The witness testified on me, but she changed her story 4 or 5 times, and those other times I never knew anything about. The Brady violation gave me X to go with the Y. And not only that, they said that the first question they asked the witness against me was, did she have a criminal record or anything? And she said no. So therefore, the prosecutor already know when they did a background check on her that she was on probation. So not only did she say she didn't have no record, she was on probation for a crime. You know what I'm saying? So she testified on me, and I didn't know any of that. If I knew any of that, I would have never went to jail. But the prosecutor knew all of that, so I should have never went to jail. But yet I see it 27 years. Besides that, it was another guy that testified on me named Ronald Lacey, if I may say his name. It's public record, but
Public record.
Right. He was adamant about me being the guy that came in the apartment building and did this crime. When he come back in 2018, when I went back to court with my Brady violation, he didn't even come in courtroom, but he had sent the message that it wasn't me. You know what I'm saying? So between this and that, I should have never went to jail. But when they found out all this stuff, they still held me, and they did an interview with me with my daughter, and the reporter said the prosecutor said that he is not totally exonerated because by it being so long, it might be some more evidence that they got to go find and dig up or whatever. The last evidence they dug up, I got some time for, but now people watching, so there wasn't no evidence for them to dig up. They just wasted another year of my life, just holding on to me, and now it's over with. One thing I didn't do, I never went to court. I went to court when I came out and they let me go, but I never went back for somebody to tell me that I was free or apologize to me or explain to my family what happened to me. The prosecutor, no one ever did that. I never went back in front of a judge. And only way I know I'm free is because I had to go to clerk of court to get a piece of paper, you know what I'm saying? And other than that, I would have never knew. But it's real hard, the way that they hold on to you, because in the back of your mind, you know that they can come and get you like they came and got you the first time. So I'm just glad it's all over with. But I wish it was better communication between the prosecutor and everybody, because they didn't say nothing to no one.
And just to piggyback off that a little bit, like they did it, like for Charles, when they decided to dismiss his case against him, they did it like it was scheduled for a pre-trial, and like they didn't tell anybody that this is what they were going to do, essentially to avoid like news cameras and publicity and people to come show up, or essentially to like try to make it as quiet as humanly possible. Is what they did. Kim, his attorney, wasn't even there. Charles wasn't there, so like they were trying to dismiss the case without anybody being there, which was just, again, very obvious as to what their motives were for that. Legally, they had to, but they were not happy about it. They didn't want people to know about it, and they were just trying to brush it under the rug and act like it never happened. So,
I'd like to say one more thing. The most insulting part about this was that an hour before I got the call saying that my case was dismissed, I got a call saying that it was a guy named Joe that I set up alibi with in January that was going to come and testify against me, and I got one more chance to take the deal, time served, and I said, no, let's go to trial. Hour after that, I got a call from my lawyer saying my case was dismissed. So I don't see no integrity with the prosecutor at all.
Yeah.
Mallory, I know you worked on Charles' case a bit. Can you talk a little bit about how the Brady violation was discovered?
Yeah, so my predecessor, Liza Dietrich, she did some public records requests to the Cleveland Police Department and then also the Cuyahoga County Prosecutor's Office. And it takes them way too long of a time to respond to records requests. So we initially got back first the prosecutor's office public records request, which usually contains, court filings, and it also will have police files. So anything basically that the prosecutor's office had for a case conceivably should be in this file. That's subject to the Public Records Act for disclosure. So we get that back, and there was a bunch of basically all of the police reports were redacted, just the substance. You could see the border and you could see that it was a police report, the date, the crime, but the substance of the reports were all redacted. So fast forward like 8-9 months, we finally get the Cleveland Police Department public records requests back that have these same police records, but that are not redacted. And it just so happened to be that the information redacted in the prosecutor's file was this Brady evidence that obviously nobody had ever seen before. Like Charles had said, there was 2 witnesses. One was a key witness. The other one was a victim, but credibility issues. So the key witness, was interviewed multiple times, that she never saw the person's face, never saw anything about them. Fast forward to trial, she's telling, yes, it was absolutely Charles, and I told the police this, and da-da-da, and none of that was true. So that's ended up in, and obviously, again, for a conviction integrity unit, it makes no sense for you to be blatantly hiding Brady material if there's a conviction integrity unit in place. Like, that's just egregious, quite frankly. And, thank God for the Cleveland Police Department and following the law for like once ever, because, that's how we got the reports back that showed all this Brady material. And so we filed our motions and stuff, and the judge was like, all right, let's have a hearing. And as we were preparing for this hearing, we also figured out that the same key witness who, like Charles said, got up and said, I have no record, had literally 6 months before in this same courthouse pled guilty to a 3rd-degree felony. So I'm not sure how that equals up to having no record, but so not only was that a Brady violation, because also in a Brady violation is if a witness's criminal history and needs to be turned over because that goes to their credibility, basically. So not only was that an issue, but also she got up there and perjured herself, and the state cannot put forward testimony that they knew or should have known was perjured. Which kind of, once we figured that out, that was kind of like the cherry on top, and it was a slam dunk. That was it, especially with how weak the case was. And then Ronald Lacey came in and was like, actually, I didn't know what I was talking about. And we were like, yeah, we knew that. So yeah, the Brady violation pretty much came about through public records requests, which is actually how we find pretty much all of our Brady violations, is getting all the records we can, reviewing them. And then either we look at the defense counsel, trial counsel's file at the time and compare. But like in Charles's case, everybody was dead. There was no file to compare it to. But there's case law basically that says, like, if there was something so beneficial to the defense, like a witness, like changing their story repeatedly, if that's not in the trial transcripts, if that's evident that that wasn't presented at trial, basically you can presume that that wasn't ever disclosed, because a defense attorney, a competent defense attorney, would have brought that up at trial. So that's basically the argument we used, and it worked. So.
And Royle, were there? I think you mentioned Brady evidence in your case as well. Was it?
Yes.
Was there Brady issues with respect to your case?
Yes, we fought so hard to get my police reports, and my lawyer couldn't get them, the OIP couldn't get them, and my wife happened to call our clerk of courts asking about something else, and for some reason the lady sent her a file over it, and it happened to carry my entire police report in there. And when we got the police report, there were statements from witnesses we never saw, police reports from actual detectives on the case that was never brought or given to us. And it was an actual vice cop on my case that played a major role that's not homicide. He had a report along with my main witness that they had kept. We never saw it until I got the file. This was like almost 12 years I was in prison. We got this file, and all these reports and these statements were in there that me or my lawyer had never saw before. My trial lawyer, I had got an affidavit from him saying that he never saw these reports, never heard about them or anything like that. So it was definitely a Brady violation. But they knew in my case I had all these things because I had built my entire case, and they knew that me getting a new trial would expose all these things they did. It would be for sure win. So they came with the deal in order to slow me down instead of going to a new trial and sit in prison for another year or 2 years. They offered me the deal.
Right.
And I just took it. I wanted to go home. And I've been home for 2 years now. I've been married. I'm having a baby any minute. So a miracle baby. I started a clothing brand. I go speak to kids in high schools and colleges and tell them about my life story so they don't follow that same path that I went through. And I'm just blessed to be here. The mixed unit made it hell for me coming home.
Can we start with maybe Charles, and then we'll come back to you, Royle? Could you talk about how the Ohio Innocence Project got involved in your case?
Well, the Ohio Innocence Project got involved in my case. I wrote them when they first opened up in 2003, and I didn't have I didn't have no witnesses. I didn't actually know what had happened in my case. So everything I knew was what I heard from someone, and I didn't know anything. And my case was just like standing still. And they didn't have the manpower, they had to help some other people. So they told me, they was going to, just not going to work on my case. But if I had got some more evidence to write them. So 5, 10, 15 years later, I had found out about some girls from reading my transcripts. And a guy said that he was with some girls in a hallway, and that he was with Nikki and Wendy, and Sweet Man came in. He walked up the stairs, he cocked a gun and said, I like to shoot people. He said, I jumped down the stairs and shot a guy in the face. He said, I shot him point blank range in the face. Jumped down the stairs and ran out the building. He laid down, tried and played like he was dead. When he woke up, he went in Nikki and Wendy's apartment. So I had to find Nikki and Wendy. And I did because, they went to school with my nieces. And I called my niece and talked to her, Tisha, and she was very instrumental in me getting back in touch with the Innocent Project. But I wrote Mark Gossi, and I started my letter off by remember me. You told me this, if I ever found anything else, I reminded him of 2003 and that, they were going to help me. And it was so fast, They went and visited my family, and they just, build an open line of communication with everyone. And when evidence started rolling in, they had already knew them. So we just start, conversations and visits and Brady violation. And here I am. But it didn't happen that fast. It was a little slower than that. But my family and my lawyers, they developed a relationship and they communicated, and everything that I found out, I got from them because they was all on top of everything. They let me know, what was going on. And but my family members were very instrumental in me getting back in touch with the Ohio Innocence Project.
Great. How about you, Royle?
I had reached out to the Innocence Project, and I was denied the first time due to they had an abundance of caseloads. It wasn't like they denied my case. They told me that they had a large amount of caseload at the time and to get back with them. And so I had filed a second application, and I don't know what happened with the second one, but I had an article written on me from the Cleveland Scene magazine by Kyle Swinson. And when he wrote that article, he gave me a front page spread, 10 pages in the inside, and he basically broke my entire case down in this 10-page article. And my wife she had a social media train going between Twitter and Facebook and Instagram about my release, and I was having rallies. And so it was the OIP. Was it Brian? Brian and Kyle know each other. So Kyle told Brian about my case, and they went and looked back and looked over it, had me fill a third application out. And as soon as I turned the application in, they came to see me within a week. And it was like, I knew I was in good hands because one of the students, Andrew Radden, had came and he knew my case from back to front. He was answering my questions. He was finishing my sentences and telling me what happened in trial. And I was like, man, I'm in good hands because I knew somebody finally took the time, because all my time in prison, I just wanted somebody to sit down, take the time, read the details. There was very small details that meant a lot of stuff. And once you found those small details that meant that big, you would just see it opened right up. It was all plain and simple. And once he saw it, he never gave up. And I guess he put fire between OIP, and they had told me I had to fire my lawyer, Kim Corral. He was like, well, not fire. He said they didn't normally do cases with somebody that had a paid attorney. But me and Kim Corral had fought so hard and so long. And I told them, and I was like, I can't fire her. And they was like, you don't want us on your case? And I was like, I definitely want you all on my case, but why y'all can't work together? I'm trying to, you know what I'm saying? Why we can't live in a world where people work together for a good cause? And they agreed to work with Kim, and here I am.
Great. We've got some questions from the YouTube channel. So Tom, this is to you. Thomas mentioned that prisoners can apply, but evidence has to be new, DNA, witness affidavits, etc. And then Royle had spoke about repeatedly being rejected with new evidence. I think he just addressed that a little bit. Can you talk a little bit about the process regarding that, Tom?
Sure. Well, it doesn't have to be in any great detail. The application, which is on the prosecutor's website, is pretty straightforward. It's what happened when, what court, what were you convicted of and the like, and then, what are you claiming to be the new evidence? And, even if it's just a sentence stating, I now have an affidavit from someone who was there, or, when Charles was telling his story, he reminded me how, searching the neighborhood and contacting family members, people in the neighborhood, they know what happened, right? The word is out, and talking to those people are really, really important. So if they put in their application, these are the 3 or 4 pieces of new evidence, or, there was no DNA tested, you had to retest the fingerprint, whatever. We'll do that. We'll go ahead and we'll run down every one of those pieces of new evidence. We'll retest the exoneration last week that we had. We retested some fingernail scrapings under the victims, and which excluded Sino Hamilton. So, if they just give us enough to, kind of take the baton and run, we'll do that. We'll do the whatever it takes. Interview people, retest, track down leads, whatever. That's what we'll do.
Great.
I'm not the owner.
Oh, okay. I better keep the owner, huh?
Yes.
You think?
Yes.
Well, you know? Okay, we're trying to make
Royle?
Yeah.
Were you asking a question?
I asked Tom a question, if that was okay.
Yeah, go ahead.
I wanted to ask Tom if there are certain procedure in the CIU that you have to follow and go by as far as communication with maybe the inmate, the attorney, the family of the inmate. Is there a procedure in you all's manual, a certain time limit that y'all communicate?
Well, good question. Well, if the person has an attorney, we have to go through counsel. They're represented by counsel. That professional code of conduct requires that we do that, and there's generally no issue. We have a call tomorrow with a prisoner, and he's represented, and the attorney will be on there. Oh, did you, Larry, outside there? So that's usually what. Otherwise, if Pierce mentioned our unit and our leader, Valerie Newman. She is so good about communicating with people that have an application in. If you sent her a letter today, I can guarantee you within 24 hours you're getting a letter back. You know, so we'll take, you know, we take calls from family members. I've talked to, you know, civilian advocates, moms, and the like. So we try to be transparent as much as we can, and keep that line of communication open.
Just from an experience, from my experience, me telling you all what I went through, like, you know what I'm saying, from me to you, like, the communication plays a major part in the whole case, because we'd be on the inside, but us not having no communication, like, guys that's in prison, this all they looking forward to, and now we cross this line where, all right, to see how you got my application, they working on my case, and then we all go missing. Like, it draws a wedge between the inmate, the family, the attorney, because don't nobody know what's going on, and we'd be in there, and we want answers. We can't just call the CIU up, so we have to call our family and our attorneys. And then when our families or our attorneys call the CIU and they not getting no news, they got to come back to us with no news, and it just causes, from my experience, it caused a lot of friction. At one point, I was ready to fire my attorney, and she the best ever. But it was like, I felt like with nobody doing nothing because there was lack of communication. Like, my wife had to literally go down there and sit in their office for like 4 hours and refuse to leave just to get an update.
Yeah, I mean, I can't speak for every other CIU in the country, but that's not the way Wayne County operates.
I'm glad to hear that.
That's good.
That's good.
See, we can't speak for, I mean, your record speak for itself, but like you said, Cuyahoga County, he the one and only. And, you know, he had a problem with communicating.
And you know what's so sad about me being the one and only today exonerated? At your exoneration, the prosecutor didn't even remember me. Months later, he didn't even know who I was. And I'm gonna go shake his hand because he freed me. So I tried to be the bigger man and go, you know what I'm saying, and shake his hand. He didn't even know who I was. And this probably was like just a few months later.
Related to that, so we've got a number of questions on the YouTube chat. The first one is to Charles, and I think it's a clarification question, but it's also related to communication, which we have been talking about. The questioner wants to know, so you were actually tracking down witnesses and evidence while you were still in prison, right?
Yes, yes.
I would imagine that's probably not an easy process.
Well,
Wasn't an easy process, right?
No. I mean, I had my transcripts and I had sent them home. I got them back. I transferred. I mean, your transcripts, like that's like your lifeline. You know what I'm saying? To your case. You know what I'm saying? Do that. You know, like years later. I mean, I'm sitting there and I'm looking. I'm just trying to figure out like different ways to get out. You know, I can't sleep at night, and if I be up like 2 or 3 o'clock in the morning, all I think about is a way to go home, you know what I'm saying, to 5 or 6 o'clock in the morning. And I might not be able to sleep, you know what I'm saying, 2 or 3 nights out the week, you know. It's like you said, the communication is the key to it, you know. Like if you're sitting in jail, you're trying to get in touch with somebody, you waiting on legal mail, and, you know, you can call your family, you know, at least communicate with your family members, you know what I'm saying, where he can call home and find out what's going on.
So the next question is to both Royle and Charles. Can you talk a little bit about how your life has been since being released from prison?
Go ahead, Royle.
It's been in one word, it's been amazing. Like, I came home and from out the gate, it was the Cleveland Browns came and got me. I did a summit for them. I came home, I did peace against the violence, gun violence walks my second day out. It was just a whirlwind. Me and my wife got married on my 1-year anniversary on the courthouse stairs where I got released at. We had officiated by my attorney, Kim Correll, that got me out of prison. I started a clothing line. It's called Comic Club, and Comic Club means continuation, because you know what I'm saying. Our life is a story, and people like me and Charles Jackson, people had wrote us off. So by us being able to shake a life sentence or 20-some plus years sentence, I felt like God put a comma on my story, and I felt like everybody got a story. So everybody need a comma on their story. So that's where it came from. And just not too long ago, I was blessed with the opportunity to have a storefront for my clothing line. I've just been trying to just show the younger generation since I've been home that you can go down a bad road and still come out on the green side and do good in your community or for others. You don't have to go to prison to do good for your community.
I guess, well, my life took off like from when the day I walked out the door. 2 days later, I was like in Cleveland State University, you know, at a summit. You know, Royle was with me. We got to meet Michael Williams, to play a character in the series from HBO, The Wire. We met him and took pictures with him. And you know, he's doing some advocating as well. You know, and it's just like things were taking off. And I went to school. I'm a chef. The biggest thing I think I can say, I gave my nephew my kidney, you know, so I mean, you know,
That ain't small time. That's big time.
Yeah, well, I gave my nephew my kidney, and we planning a trip for his birthday. His birthday is like today, and we're planning a trip to not North Carolina, Memphis, Tennessee. And before I gave him the kidney, he was on dialysis like 3 times a week, you know what I'm saying? And he wasn't going on no trips. No, there's gonna be like big celebration coming up like in a week or two. I'm trying to get my food box, but you know, the coronavirus.
Your food truck, man, that's your food box.
You know, I'm nervous, but yeah, I'm trying to get the food truck off the ground, but the coronavirus stopped all that. But now it's like we got to reinvent the wheel now. So it might be a good time for that food truck to come out, you know, since there's a lot of takeout, and I might can take the food to the people because, you know, we got to eat, and ain't nothing like some good French fries, you know what I'm saying? So, I think I'm gonna try to get that food truck rolling. But other than that, and I'm a grandfather too. My daughter had my grandson. He's like a month old, and you know, things moving on. You know, life's good.
Great. So this is actually to all the panelists. So the question is, what role do you believe that race plays in wrongful convictions?
A huge giant role.
This is good. Race right now, this is like it's a revolution going on. You know what I'm saying? It is gonna be televised. It's gonna be on the internet. You know what I'm saying? All around the world. Race. We finna talk about race now. It's just like the elephant that's been in the room, and now it's time to talk about it. You know, no more talk. It's time for action. You know, we're gonna do this prison reform thing. We're gonna free some of them brothers that's been in jail way too long. You know what I'm saying? Far as me playing pardon, I can't march and none of that stuff down, and I ain't going to none of those rallies. But I'm gonna tell my story. You know what I'm saying? I'm gonna tell you my perspective on, you know, what they did to me, and hopefully, you know, somebody can make some changes. You know what I'm saying? And I think the youth today is what's happening. They're gonna get rid of Donald Trump first, and the sky's the limit. You know.
Man, for me, in my case, I would say race played a major part in my case just because I had a majority of white jurors or Caucasian jurors. And my case revolved around a lot of things that was from my neighborhood. So I feel like in certain cases, race played a big part, especially with juries and things of that nature, because you get a lot of people that's judging the case that's not from that background, that culture. It's going to be a mix-up. And in my case, the description was the biggest thing in our case. Every witness in my case kept describing the 2 suspects as 2 light-skinned individuals that came and left. I'm far from light-skinned, and this crime happened at 12:30 at night on the side street. That made me even darker at night. But my jurors, by them being majority white from the suburbs, they don't see, like, in description, they don't see light skin and dark skin. They see two African American males. So that was the only part they kept hearing was African American males. They failed to hear the light skinned part. Now, had you got a split juror where you got African American 6 and white 6 from the suburbs, somebody in that jury will be like, hold on, wait a minute. This brother not light skinned. We can't even go further. We can't even, he shouldn't even be in. I shouldn't have even been in the courtroom, period, because I never fit the description of the suspects from the beginning. But when you have people that's not from my background or from my culture, it's hard for them to know that. So right. I feel as though, like, going forward, it needs to be that mix. It needs to be split down the middle or whatever it is. Like, this person from that neck of the woods or that area, we need somebody from that neck of the woods, that area, to be on that jury. So it could be a clean understanding. Yeah. Yeah.
Jury of our own peers.
Because I wasn't jury by my peers. I was 22, 23 years old. Everybody in my jury was majority white from the suburbs and it was 30 plus. That's not, to me, that's not my peers, because they didn't understand the lifestyle or where I came, how I was born, where I was raised at, or anything like that.
Yeah, I would say if you look at, just look at the numbers from the National Registry of Exonerations, that's pretty telling, those numbers. And, you know, to Royle's point, I mean, there's been lots of research done in confirming cross-racial bias that, you know, a white person really can't describe a black person, and it goes across. You know, I've been involved in some cases here with the Arab community, and it even crosses over that way. So there's no doubt in my mind that plays a role.
Oh, dang.
Thank you for that, Tom. I appreciate that response. Thank you so much. Very honest. I appreciate that. It means a lot to me, and I don't even, but it means a lot to you if you hear you say that.
Thanks.
Most of the prosecutors and people on that side of the fence, they have a one-track mind. It's like they make every excuse in the world up before they admit that there is an off balance in these situations. So I commend you as a man for that.
The next question is for Royle and Charles. I think you could probably go on and on about this next question, but the question is there anything that you wish you would have known about the judicial system going into your first trials that you did not know?
I wish I would have paid more attention to social studies. For real. It's just like I was naive to think that I didn't have anything to worry about, you know, because I didn't do anything. And so I had a false sense of security in, as I said, like the prosecutor, wrapping myself around the flag, you know. I thought, you know, being, you know, innocent was going to mean something.
Yeah.
Innocent until proven guilty. I was guilty and had to prove my innocence.
And I think that the struggle there is, you know, innocent people don't know anything about the crime, right? So this idea of it's tough to help yourself when, you know, I wasn't there, I didn't do it. So you know, it's sort of like you're starting way behind the starting blocks.
Right.
Yeah. To chime in on that, I definitely do think so, because I mean, I wish I would have knew more that I learned now. Like, things as simple as though when you subpoena somebody to court, like, you have a right to have your proceedings postponed until the courts find that person. I didn't know that. We had subpoenaed, like, the vice cop on my case. I subpoenaed him to my trial. I subpoenaed the other individual, the second suspect that was actually there with my co-defendant. I subpoenaed him once we had realized his name. He was subpoenaed, and they didn't come to court. And so they just went ahead and went through court without them showing up. And I didn't know back then that I could have halted the proceedings. Like, I really need these people to come to this court proceeding because they can help my case. It's just things of that nature. And it's like you have these attorneys that know these type of things and allow these things to go on and know that they're not right. So it's not all on the prosecutor sometimes, because sometimes it be the defense attorneys let certain things slide that might be detrimental to the case for real, and they don't put the fight up that they should. So it's not all y'all times, it's not just all y'all sometimes.
Right. I didn't have a public defender. I had a public surrender.
Great. We've got about 10 minutes left. So obviously there's a lot of young people watching this broadcast, future lawyers and judges and journalists and college professors and all kinds of folks watching. For a wrap-up question, do you want to maybe make one last comment that you would like these folks to remember about what about our program this evening? And so maybe we could start, just go through in the order that we started the program. So Pierce, would you like to go first?
Sure. I think everything's pretty much been said, but to remind people, make sure you vote and make sure you vote smart. Royle and Charles both mentioned something equally important. If you get a summons for jury service, go serve on the jury. Aside from the fact that you have that responsibility as a citizen, and one that you should be thankful, what both of their cases illustrate is how important that is. Nationally, only 5% of criminal trials go to jury. In Ohio, it's 2%. And innocent men and innocent women will go to trial because they're innocent. Being innocent can be a risk factor for wrongful conviction because those men and women trust the system will do the right thing. And over again, I know from clients, the first time they realized they were in trouble was when the jury foreperson said guilty. And that's a horrible tragedy, but I often wonder if more people served on juries, if things would be different. There's a reason that jury pools, or at least juries that we see, are older white people. Those are people who want to serve on a jury. And I'm not saying it's not inconvenient in your life in the short term, but that inconvenience is something that could change someone else's life dramatically. So please make sure you go to jury if you're called. And then just the last point is one that we alluded to earlier. You don't have to be a lawyer or a forensic analyst or a judge. There are so many ways you can be influential in stopping wrongful convictions and addressing them. And journalism is one of the most powerful ways that happens. Kyle Swenson was not only at the scene and helped in Royle's case, he has written about almost all of OIP's clients. And he's got a great book, Good Kids, Bad City, which is about 3 of our other clients and one of the most compelling stories you could ever read. So for all of you at OU over in Scripps or at one of the communication schools, just know that you play a part, and anybody out there who's not interested in law, there's ways you can help.
Tom?
Thanks. I echo what Pierce said, particularly about local elections. Your prosecutor, in the criminal justice system, I would submit that the prosecutor is the most powerful person. That person charges, that person signs warrants. There's a great book out by Emily Bazelon, I think, called Charged, and it talks about the power of the prosecutor. So I would reinforce that. And then I think too, there's so many ways you can help in this fight, this effort. And while it can be directly tied to the criminal justice system, like Pierce was saying, you could be a lawyer, you can be a investigative reporter, you could be a social worker, whatever. But let's remember how we all got here. There are systemic practices and institutions that have marginalized people. So you can be a teacher, okay? You can be a counselor. There are so many things because, you know, it's great to, you know, feed the poor, clothe the poor. But when you got to ask, well, why are people here in this country poor? And the same goes for in the law enforcement, all these issues in the criminal justice systems. Why are we here? And so there's so many ways that you can support people so we don't end up here.
So I would back off what they said. How important it is to vote in your elections. Like Tom said, you know, that specifically impacts criminal justice issues. And then, you know, even just being educated and keeping yourself educated on wrongful conviction issues. If you look at where we were 10 years ago, you know, people, you know, eyewitness IDs weren't, you know, we've come a long way with all of these things we now know as causes of wrongful convictions, and that's just, there's just straight up education. So keeping yourself educated with books or documentaries or, you know, whatever the case may be, you know, and then that will continue these conversations and we'll get further and further with, you know, reform and, you know, and also I will plug law school. I love law school, we'll go to law school, but if you don't want to, that's okay. But
Charles?
Well, I just like to say, time now is for the youth, and scream and make sure you be heard. The world is yours.
I just want to say to the youth that's watching, that is pursuing law, don't always think you have to be a defense attorney to change the system. We need more prosecutors and more judges from this generation that's coming about. So just keep that in mind and just try to stay in school and stay out of trouble. And always remember that your life decisions now will affect you and others later on in life.
Sure.
Great. Well, I want to thank you all for attending our program this evening. I want to say special thanks to our panelists, Mallory, Pierce, Tom, Charles, and Royle, and of course, Kira, for joining us here this evening. Thank you to the Ohio Innocence Project and the OIP-u chapters at the University of Cincinnati and Ohio University for co-sponsoring this program. Thank you all and have a wonderful evening.
Go Bobcats. All right.
Go Bobcats.
That's right.